prenuptial agreement, or a prenup for short, is a contract between two people who are preparing to get married that determines how their property will be divided in the case of a divorce. In Nebraska, this contract is also called a premarital agreement. In this video, we'll cover what prenuptial agreements are, how Nebraska law handles them, and how to draft a prenup that won't get thrown out of court. Make sure that you watch to the end of this video so you can download a fillable prenup template. Prenups used to be taboo, but today our society and courts acknowledge that divorce happens. So these contracts are increasingly becoming a common feature of a couple's financial plan. Prenups can determine arrangements for all property, assets, obligations, and debts. They cannot, however, be the final word on child custody or child support. These are matters decided by the court, which is legally mandated to protect the child's best interests. Nebraska adopted the Uniform Premarital Agreement Act, which was written in 1983 to standardize prenup laws across the country. Under this law, a prenup will hold up in court if it meets a few criteria. First, both parties have to have entered into the agreement voluntarily. Both need to demonstrate at the time of signing the agreement a complete and correct understanding of the other party's financial situation. In order to be legally enforceable, the prenup also has to be unconscionable, which means it's basically and fundamentally fair. We know from Nebraska case law that a prenup can still be upheld even if some provisions are declared unconscionable. This isn't the case in every state. Making sure your prenup is conscionable, though, is important. There are a few ways that you can do this. A judge might consider a prenup signed just before the wedding unconscionable, so it's best to get this document drafted and signed months ahead of time. If both parties did not have a chance to consult with separate lawyers, a judge might consider the process unconscionable too. If either party hides information about his or her finances before signing the agreement, it can also be deemed unconscionable. So, if you want your prenup to be enforced, it's good to get your own lawyer and to be completely honest about your financial situation. Case law also shows us that if there is inequality between the parties in terms of age or sophistication, there may be grounds for declaring a prenup unconscionable. So if you are much older and much wealthier than your spouse or vice versa, you may want to take extra care with your prenup. One other thing to note is that the prenup can't limit one spouse's financial circumstances so much that he or she has to then depend on the state for support after a divorce if the other spouse is in a position to continue providing that support. In Nebraska, a prenup has to be in writing and signed by both parties in order for it to be valid. In the case of a disagreement, the disgruntled party has the burden of responsibility to prove that the agreement should be declared null and void. You can get an agreement that will be accepted by a Nebraska court at the link right here. And don't forget to hit that subscribe button so you can access more videos that will help you navigate some of life's most confusing and costly situations.